Good morning, everyone. Thank you for joining us for the Medical Board of California's quarterly board meeting. Pursuant to the provision of Governor Gavin Newsom's Executive Order N29-20, dated March 17, 2020, this meeting is being conducted via WebEx. Public comments will be heard for each agenda item for individuals wishing to do so. In order to be ready for public comment, we ask that you please ensure your comments can be heard clearly by connecting to the audio of this meeting through the proper method. If you are having difficulty hearing the audio of this meeting, it could be because the device you are connected with has bandwidth limitations. If you do have difficulty hearing the audio of this meeting from your device, please click the ellipsis button at the bottom of the WebEx application or the Communicate menu item at the top of the WebEx application, and then select Audio Connection. You will see an option to call in and will be provided with a telephone number, access code, and attendee ID that can be used to connect to the meeting audio via phone. Using the information provided, it will automatically disconnect your device's audio and connect your phone to the name that you joined the meeting by. Using this method, if you are having problems with your audio with your device, you will still be able to participate and hear the audio of the board meeting through your phone. Please see the instructions on how to connect link on the last page of the meeting agenda for step-by-step WebEx instructions, including screenshots. Thank you, President Lawson. You can now start the meeting.
Thank you, Sean, and good morning, everyone. Welcome to day 2 of the quarterly meeting of the Medical Board of California. It's February 5th, and we're getting started promptly here at 9:04 a.m. Welcome also to the members of the public that are joining us this morning. I see that there are 30 or more of you, so thank you for joining us, and we look forward to your participation in the meeting as well. If you'll bear with me, I have some formalities to go through. Of course, since this meeting is being conducted via WebEx, I will ask that all board members and speakers alike please announce themselves by name before speaking, just for clarity of the official record. All board members are able to unmute themselves to speak during the meeting. Please place yourself back on mute when not speaking to reduce the background noise for all participants. During each call for comments from board members and speakers, we will ensure that all comments that can be accommodated are heard before proceeding with the agenda. Government Code Section 11126.5 allows the board to remove people who willfully interrupt a meeting and to clear the room or virtual space if order cannot be restored by removing or muting the disruptive people. We will have a designated time on the agenda for public comment, and we'll ask for public comment on each individual agenda item. This is an official business meeting of the Medical Board of California, and as such, disruptions will not be tolerated. The board welcomes and invites public comments on any item on the agenda, and it is the board's intent to ask for public comments prior to the board taking action on any agenda item. During each agenda item, the host moderating the WebEx event will activate the Q&A feature of WebEx and will ask anyone wishing to make a public comment to indicate so by replying yes. The host will then call on individuals who indicated they wish to make public comments by name. When called upon, the host will unmute the microphone of the individual, and you will have 3 minutes to make your public comment. The host will audibly announce when 15 seconds remains to conclude the public comment. And after the 3 minutes for public comment has lapsed, the individual will be placed back on mute. Only one public comment per agenda item is allowed per attendee. Please do see page 4 of the agenda for today's meeting for the WebEx instructions on how to connect from the link on the agenda and additional instructions. During agenda item 16, which is public comments on items not on the agenda, the board has limited the total public comment period for individuals to 40 minutes. Therefore, after 40 minutes, no further comments will be accepted. During public comment on any other agenda item, 20 minutes will be allowed for each public comment period. After 20 minutes, no further comments will be accepted. And again, each person will be limited to 3 minutes per agenda item. The board's IT staff will assist me with receiving the public comments via WebEx during this meeting. And I'd like to remind speakers to please stay on topic and keep your comments to the allotted time or less. Today's meeting will be run in accordance with the Open Meeting Act as required by law. And we do plan to end today's meeting by 2:00 p.m. I would like to now call the meeting formally to order and ask that board members please unmute their computers. Ms. Caldwell, please call the roll.
Ms. Campovati. Present. Dr. Canada.
Present.
Dr. Hawkins.
Here.
Dr. Kraus.
Here.
Ms. Lawson.
Here.
Ms. Lubiana.
Here.
Dr. Lewis.
Present.
Dr. Mahmood.
Yes.
Dr. Thorpe,
Here.
Dr. Tirado,
Here.
Mr. Watkins, Dr. Yip.
Here.
Thank you.
Thank you. A quorum is present, and board members, please place your computers back on mute. I would also like to remind the members that we'll be taking a roll call vote today on all action items. Now moving on to item 16, which is public comments on items not on the agenda. Before I do invite public comment, I would ask the individuals making comments to not discuss any pending complaints, pending license applications, or pending disciplinary actions that may come before the board for a decision. Such discussions would be considered ex parte communications and could provide information to the members that is outside of the record in violation of the Administrative Procedure Act. And therefore, such discussions could create a conflict and lead to a board decision being challenged. The board can receive comments regarding the board's processes in general, but like I said, it cannot receive comments on specific case circumstances where the decision is still pending. In addition, the board would like to ask that the public address the board as a whole and not individual board members. Please do be aware that public comment during this agenda item should provide information to board members and is not a discussion between the board members and the public. The only action board members can take is to listen to comments and decide whether they want a future agenda item on the topic. No other action can be taken on the item at this meeting. Though this may seem at times like board members are not being responsive, following these guidelines is critical to ensuring the rules of the Open Meeting Act are followed and to avoid compromising the speaker's goals or the board's mission. If you want to comment on an agenda item, please do wait until we get to that agenda item. Comments at this time are limited to those items not on the agenda. And again, we'd ask you to limit your comments to 3 minutes. Sean, please now open up the Q&A for public comment.
Okay, anyone wishing to make a public comment, please indicate just by typing yes or anything into the Q&A window, and we'll call on you in the order requested or received. First up, we have Eric Andrus. Eric, are you there?
Yes, I'm here.
Please go ahead.
Well, comes the dawn. Yesterday's long meeting turned out to be very informative indeed, didn't it? And now we have even more evidence to present to the legislature for the sunset review. A few meetings back, Ron Lewis says on video, quote, "Things happen in medicine, they just do. They're tragedies, but we can't hang everyone," close quote. Well, Ron, it's your job to hang everyone that harms a patient or breaks the law. It's not up to you to let doctors off the hook because there's not enough money in the bank account or because medical board staff is lazy and screwed up the evidence. Back when Judge Feinstein was on the board, she criticized Gloria Castro and her know-it-all attitude, recalling a case where a DAG had screwed up so badly with the evidence that the case had to be closed. Gloria Castro tried to make it sound like she wasn't positive that Judge Feinstein knew what she was talking about, because surely Gloria is smarter than a notable judge, right? But said she'd look into the matter. We asked Gloria for updates several meetings in a row after that, but she chose to be non-transparent and withhold that important information from the public. Not long after that, Judge Feinstein turned in her resignation stating, quote, "Due to reasons both personal and professional, I can no longer continue to fulfill the important duties of a board member in a manner that meets the standards I set for myself," close quote. Clearly, she recognized that the medical board standards were subpar. The interesting thing was after that, you all just continued on accepting the subpar standards, continuing to close legitimate complaints, continuing to not follow your own guidelines, continuing to barter with bad doctors and letting them continue to practice after killing patients, continuing to let doctors practice who sexually assault patients, and continuing to accept Ron Lewis's disintegrating mental and physical health and his attitude that you can't hang everyone. It's shameful and disgusting. But now that TJ has validated so many of the suspicions we've had over the years, you're all going to be watched to see if you continue to toe the medical board's broken system or help expose it so that we can create a medical board that actually does what it's supposed to, protect consumers. Each and every one of you from this day forward that chooses to accept the status quo and protect bad doctors is going to be held accountable for those actions. I'm not afraid to call each and every one of you out publicly and in the press. Just ask Howard what happened after he tried to take away our First Amendment right to free speech. Since I'm running out of time, Jeff Rizzo will finish me on his call. Hey, Deb, since you're in Hawaii, could you pick me up some macadamia nuts? Thanks.
Thank you for your public comment. Next up, we have Marion Hollingsworth. Marion, are you there?
Yes, I am. Can you hear me?
Yes, we can. Please go ahead.
Good morning. My name is Marion Hollingsworth, patient safety advocate. I would like to further comment on the issue that was raised yesterday regarding the board not following disciplinary guidelines and in some cases ignoring them completely. A recent case comes to mind about a Lakeport doctor who was found responsible for the deaths of 4 patients, 2 with a death certificate project, and yet he receives just 3 years probation. He is still practicing and does not have to notify patients of his probationary status because he was given less than 5 years. How does this protect the public? Most people still don't know how to go on Breeze to look up doctors to see if they are safe and then their records are clear. Please address the issue of why you often do not follow disciplinary guidelines at your next meeting. Thank you.
Thank you for your public comment. Next up, we have Susan Lauren. Susan, are you there?
Yes, hi, can you hear me?
Yes, we can. Please go ahead.
Thank you. I'm Susan Lauren, a survivor of surgical assault. Trying to obtain justice and protect others from medical perpetrators is devastating to survivors in California. We continue to be secondarily harmed by cruel, widespread institutional betrayal. Perpetrators, special interests, and opportunists target survivors with false blame, threats, gags, and slander. Word among the harmed community is that the process of filing a medical board complaint is demoralizing and fruitless, so many don't do it. I suggest you figure these people into your so-called statistics. Saul Berger stabbed me dozens of times into muscular areas against consent or rationale and removed needed, wanted parts of my body. Your board didn't take action, so you didn't stop Berger. Additionally, I lost the trial. Dr. Dubrow lied in my case, and the jury felt they had to regard what he said because of his medical board credentials that the defense used as his selling point. Plastic surgeons should not be experts for each other. They do scams. Terry Dubrow hurt me in his office, aborted the exam, bragged about the $3,000 an hour he made for the depot, and perjured himself. Berger's lawyer, Tom McAndrews, blamed me for not going back to Berger, my assaulter. Tom created slanderous diversions to confuse the jury. He talked about egregious surgical battery as if I am disgruntled and crazy. Doctors and their boards have convinced the public that they have exclusive claim to knowledge of the body. Before Berger disabled me, my career for 25 years was as a skilled physical and movement therapist. I taught anatomy and kinesiology. My friend and colleague Ann wrote, once Susan recovered sufficiently to grasp the extent of her mutilation, she faced a band of brothers, people who shared responsibility in some way for the cavalier treatment that had led to her pain, disability, and disfigurement. She sued the doctor. Unsuccessfully. She took her case to the Medical Board of California. Unsuccessfully. She contacted her state legislators. Unsuccessfully. They were unmoved by damage done or unable to take on the system. Some even disparaged her intent, saying she must have asked for it. Let me assure you, Susan did not ask for it, nor was she fat or lazy. She was a level-headed person seeking to resolve a medical problem. That was breast reduction. Now she has been disabled and rendered housebound. She's seeking help from federal, state, and local regulators to protect unsuspecting patients from the dangers of liposuction. Will you help or stay silent? I request these changes.
30 seconds for me.
Thank you. Make surgical assault a crime. Require truth in advertising for liposuction. Change the noxious California Lipo Code. Have patients participate in and approve their own records. Abolish MICRA. Stop empowering dangerous doctors. Stop normalizing medical scams. I want to thank TJ and thank you for your time.
Thank you for your public comment. Next up, we have Jeff Rizzo. Jeff, are you there?
Yes, I am. Can you hear me?
Yes, we can. Please go ahead.
Yes, this is Jeff Rizzo from the Patient Safety League, and I'm going to be continuing Eric's comments for him. Did you all see the news yesterday, the news story yesterday on the quote of the DMV? California State Auditor Elaine Howell said, quote, the problem is with management, noting the department, like a lot of state agencies, is just entrenched in their traditional processes, close quote. From what we can tell, the medical board has never been audited. We could only find an audit of Breeze on the state auditor's page, and it failed miserably, by the way. The Board of Registered Nursing was audited this past June and were not only caught with a ton of failing systems, but were also caught faking documents which they provided to the state auditor. So when you all sit back and think that the staffs of these agencies can do no wrong, you need to think again. You all should read the state auditor's report of the nursing board. Perhaps it will change your mindset. It's amazing how people that run and work for these boards think they're so much better than the public and think they can skirt the laws and pull the wool over our eyes. It's really very much how Carrie Webb skirts the Public Record Act law to protect the board from the public finding out exactly how much they're doing wrong. We're catching up though, Carrie, and it's going to come back and bite you in the butt. We promise you that. The fact that the rest of you sit there time and time again and allow her to block discussion about the Public Record Act makes you all accomplices to this cover-up. The fact that none of you seemed alarmed that the DCA subpoenaed Eric's personal Facebook records really points out your true colors as human beings. If I were on the board, you can bet that I wouldn't just sit back without voicing my disapproval for that kind of invasion of privacy. But then again, you all sat back and praised Kimberly Kirchmeier after the board was sued by an employee for allowing her to be sexually attacked by a medical board supervisor, and Kim refused to report it. It's just shameful how fearful most of you are about speaking up for what's right. Now you all just applaud her as she gets a promotion. It's disgusting. Kim Kirchmeier is disgusting. And back to the audit, if you all really want this board to be better, if you really want the legislature to know why your systems are failing, if you want them to understand just how much money it takes for this agency to function properly in the name of consumer safety, you yourselves will request that this agency be audited. If you have nothing to hide, if you think no one's skirting or breaking the law, you should have nothing to fear by an audit, right? On the other hand, if you know that this agency isn't doing the best it can and that certain individuals aren't following the laws, then your ongoing silence will continue to prove exactly that. Thank you.
Thank you for your public comment. Next up, we have Christina Hildebrand. Christina, are you there?
I am, yes.
Please go ahead.
Hi, my name is Christina Hildebrand. I'm from A Voice for Choice Advocacy. We educate and advocate for informed choice and transparency of what goes into your body. As I mentioned yesterday, I'm disappointed that we still don't have any public input into these meetings. You listen to the same 5 people that come on every single medical board. If there are a meeting, if there are other issues at hand, others show up. But the 5 of us have a very similar message to you. Please listen to us. Please, have the community work with you. We're all open and willing and happy to work with you to make the medical board a better place and to make it consumer centric rather than doctor focused. Today, I wanted to talk furthermore about standard of care versus the newest treatments. So one of the things that I find amazing is that, the other people that talk in public comment are concerned with how you don't follow up on doctor complaints. My issue is SB 276 and 277, which are the medical exemptions. For those doctors that have been witch hunted by nurses and other doctors and the medical board and being reported for writing medical exemptions, you seem to do the opposite. You seem to be able to get down on them and put them on probation rapidly and very easily, even though they are using the newest research rather than standard of care. And I really ask that the medical board look at this standard of care versus newest treatments, because the doctors that are writing medical exemptions that you have brought before you have used this newer treatments and the newest research versus standard of care. We should applaud them for being advanced in their practices. If they were at the Mayo Clinic doing this, you wouldn't bat an eyelid, but yet because it has the word vaccine, which seems to be toxic, it suddenly becomes you can only use the standard of care and the CDC contraindications and precautions. If we went with that for any other drug, with any other treatment, with any other diagnosis, we would be in the dark ages still. So I ask you really to look at the standard of care, and I would love for you to I'll bring it up on the agenda item at the end of this meeting again, but doesn't seem to matter what anyone says from the public of asking for agenda items because they never seem to get put on the agenda. But I will ask for it again, that you look
30 seconds remain.
at standard of care versus new treatments, new research, and taking into consideration worldwide new research that doctors are using. Thank you.
Thank you for your public comment. Ms. Lawson, at this time, I don't see any other requests in the queue.
All right, thank you. And thank you to all the public commenters for your comments and for taking the time to be with us today. Moving on to agenda item 17, which is update, discussion, and possible action on proposed agenda from the Midwifery Advisory Council. Ms. Holzer?
Good morning, everybody. Thank you for your time. I am here just for you to look at the agenda and approve it for us if you can. Our requested action is to approve the
Ms.
following.
Holzer, we're just having a little bit of, I'm just having a little bit of trouble hearing you. I don't know if that's the same for other members that
Is it
getting a
better
little bit,
now? Can you hear me better now?
it's a little bit, yes, thank you.
Okay, all right, just need to get closer. All right. So we would like you to approve the following agenda items for the next Midwifery Advisory Council meeting. Establishing goals for the MAC, update on midwifery related legislation and sunset review, report from the MAC chair, update on the midwifery program, discussion and possible action on proposed regulatory language for the licensed midwife annual report, approval of the minutes from the December meeting, selection of 2 new MAC members, 1 licensed midwife position and 1 public member position, and report from the task force and discussion regarding Medi-Cal related issues. The background, the last MAC meeting was held on December 3rd, 2020. At this meeting, the following actions were taken or the MAC was provided the following information. We approved the meeting minutes from the August 20th meeting. We received an update from the MAC chair, an update on midwifery legislation, an update on the midwifery program. We voted on our next meeting dates. We received a report from the task force regarding the data collected on the LMAR. We received an update on the sunset review and a report from the task force regarding a draft letter to the birth certificate clerks and Social Security offices. And we received a report from the task force on action regarding legislative solution to address stalemate on creating regulations for licensed midwives. And that's it.
Thank you, Ms. Holzer. Are there any questions or comments from board members? All right, seeing none immediately, I will now ask the host to call for public comment.
Okay, the Q&A window is open for anyone wishing to make a public comment on agenda item 17. Please go ahead and indicate so in there, and we'll call on you in the order you received. Okay, this time, Ms. Lawson, I'm not seeing any requests.
All right, thank you, Sean. I will bring it back to the board. Any questions or comments, or may I have a motion to approve the agenda?
Dr. Hawkins, so moved. Second, TJ Watkins.
Thank you. We have a motion and a second. Is there any further discussion? All right, seeing none, Ms. Caldwell, please perform the roll call vote.
Ms. Campoverde?
Aye.
Dr. Gonadev?
Aye.
Dr. Hawkins?
Yes.
Dr. Kraus?
Yes.
Ms. Lawson?
Yes.
Ms. Lubiano?
Yes.
Dr. Lewis?
Aye.
Dr. Mahmood?
Yes.
Dr. Thorpe?
Yes.
Dr. Tirado?
Yes.
Mr. Watkins?
Aye.
Dr. Yip?
Aye.
Thank you.
Thank you. The motion carries. We'll move on to the next item, 18, update on interested parties meeting regarding proposed revisions to the practice guidelines for California licensed midwives. I think Dr. Kraus?
Yes.
For handling this item. Thank you.
The interested parties meeting on the proposed revisions to the practice guidelines for California licensed midwives was held on January 14th, 2021. Due notice was provided to all interested parties, and all public comments received in writing by the deadline were made available on the board's website. The meeting was moderated by myself and the board staff attorney, Mary Webb. There were approximately 30 participants at the meeting, and approximately 7 of those attending made public comments. By way of background, in 2005, the board approved the standards of care for California licensed midwives, which were incorporated by reference into Title 16 of the California Code of Regulations, Section 1379.19. AB 1308 became effective in 2014 and made significant changes to the Midwifery Practice Act, including removing physician supervision over licensed midwives, but requiring licensed midwives to refer their clients for an examination by a physician trained in obstetrics and gynecology if their client had a pre-existing maternal disease or condition likely to affect the pregnancy, or had a significant disease arising from the pregnancy. The licensed midwife would be able to assist their client in pregnancy and childbirth only if an examination by a physician trained in obstetrics and gynecology is obtained, and the physician who examined the client determined that the risk factors presented by the disease or condition are not likely to significantly affect the course of pregnancy and childbirth. AB 1308 also rendered Section 1379.19 and the Standards of Care for California Licensed Midwives out of date. Board staff worked with the past chair of the Midwifery Advisory Council, also known as MAC, to develop the practice guidelines for California licensed midwives to provide a guidance document consistent with current law under AB 1308. The MAC approved the guidelines at its March 27, 2014 meeting, and the board approved the guidelines at its May 2014 quarterly board meeting. Recently, at its March 2020 meeting, the MAC reviewed the practice guidelines for possible revision. After further discussion at its August 2020 meeting, the MAC voted to significantly revise the practice guidelines. At the November 14, 2020 board meeting, the MAC recommended that the board approve the proposed revisions to the practice guidelines. At that time, the board decided to hold an interested parties meeting to hear further discussion on the guidelines and the proposed changes. At the interested parties meeting, the majority of the public comments recommended rejecting the modification of the guidelines in favor of focusing efforts on developing an independent midwifery board. The Medical Board Sunset Review Report recommends the creation of a midwifery board. This concludes my update on the interested parties meeting.
Thank you, Dr. Kraus. Are there any comments or questions from board members?
Dr. Hawkins, may I speak? Dr. Kraus, was there a specific reason why the modifications were not adopted?
Well, you'll have to refer to the minutes of our board meeting.
Okay.
But as I recall, the modifications were mostly to remove the guidelines, and in that this was a dramatic change, and in that we're also in a legislative cycle where we might find that the medical board no longer has supervision of midwives. The thought before having the board make a decision on revising the guideline was to hold an interested parties meeting. And most of what I heard at the interested parties meeting was that most of the callers felt that this should not be the purview of the medical board, that, again, we need to move toward legislative redress, perhaps with a independent board of midwifery. So a revision of the guidelines, in fact, at this juncture, could be moot.
Thanks, Dr. Kraus, and that's what I meant in terms of what the comments that occurred at the interested party meetings. Thank you.
You're welcome.
Any additional questions or comments from board members? All right, seeing none, Sean, would you please open up the Q&A for public comment?
Yes, the Q&A window is open again for anyone wishing to make a public comment. Please indicate so. Give it a few more seconds here. Be sure. Okay, at this time I don't see any requests.
Thanks, Sean. And given that this is just an update item, there's no action for us to take. And so we'll now move on to agenda item 19, Discussion and possible action on the recommendations from the Special Faculty Permit and Review Committee. Dr. Gananadev?
Good morning. Actually, good morning from Hawaii. I wish I was there. Thank you, Madam Chair. Special Faculty Permit Committee on December 9, 2020, Special Faculty Permit Review Committee held a teleconference meeting. During the meeting, the committee reviewed and discussed the application of Dr. Pedro Catarino for special faculty appointment with the University of California, Los Angeles, David Geffen School of Medicine. Please turn to agenda item 19 in your meeting packet for a detailed report on Dr. Catarino's qualifications, medical school, and postgraduate training. Interestingly, this is the only guy I know who went to both Oxford and Cambridge. It's unusual. Those schools, they compete with each other everywhere. Dr. Catarino's area of expertise in the field of aortic surgery, including minimally invasive techniques, mechanical circulatory support, and heart-lung transplantation, with particular expertise in donation after circulatory death. Dr. Catarino is currently visiting associate professor at UCLA David Geffen School of Medicine. Dr. Catarino is an active researcher and has received a number of grants for his work, has an excellent bibliography in his field, is a busy local, national, and international lecturer and educator, and has received a number of research fellowships and clinical excellence awards. Dr. Catarino was previously appointed as the Director of Transplantation and Mechanical Circulatory Support at the Royal Papworth Hospital in Cambridge. Dr. Catarino's innovative surgical techniques and unique expertise in minimally invasive thoracic surgery and transplantation will enable him to introduce these new techniques, unique surgical techniques at UCLA and Cedars-Sinai Medical Center. If approved by the board, Dr. Catarino will hold a full-time faculty position as Health Sciences Associate Professor at David Geffen School of Medicine at UCLA and will serve as Surgical Director of Aortic Surgery at the school's major affiliated Cedars-Sinai Medical Center. UCLA has demonstrated that Dr. Catarino is clearly outstanding to hold a full-time professor clinical faculty appointment at UCLA. The committee reviewed Dr. Catarino's application and qualifications and recommends that the board approve Dr. Catarino's application for a special faculty permit. This concludes my report. Are there any questions from the board?
Thank you, Dr. Gananadev. Are there any questions, comments from the board members?
No, I move to accept the recommendations of the special faculty permit as reviewed by Dr. Gananadev.
Second.
Thank you, Dr. Lewis. Thank you, Dr. Kraus. I will now ask for public comments before we take a vote on that motion. Sean, could you open the Q&A? Thank you.
Yes, Q&A window is open. If anyone would like to make a public comment, please indicate so. Just a few more seconds here. Just to... Yeah, at this time, Ms. Lawson, I'm not seeing any requests.
Thank you. We'll bring it back to the board. Are there any final questions or comments before we vote on the motion on the table?
Yeah, Madam President, actually, I'm supposed to say the entire thing, but Ron beat that. So it is under the Professions Code section 2168 1A 1B, special faculty permit appointment at the University of California, Los Angeles, David Geffen School of Medicine, so that we have it officially what it is.
Except.
Thank you. All right. Ms. Caldwell, will you please perform the roll call vote for us? Thank you.
Ms. Campoverde?
Aye.
Dr. Gananadev?
Aye.
Dr. Hawkins?
Yes.
Dr. Kraus?
Yes.
Ms. Lawson?
Yes.
Ms. Lubiana?
Yes.
Dr. Lewis?
Aye.
Dr. Mahmood?
Yes.
Dr. Thorpe?
Yes.
Dr. Torado,
Yes.
Mr. Watkins,
Aye.
Dr. Yin.
Aye.
Thank you.
Thank you, Ms. Caldwell. The motion carries. We'll move on to agenda item 20, discussion and possible action on recommendations from the Application Review and Special Programs Committee. On January 20th, 2021, the Application Review and Special Programs Committee held a WebEx meeting, and during that meeting, the committee reviewed and discussed staff's recommendation to delegate authority to our board staff to grant certain extensions to postgraduate training licenses. According to Business and Professions Code Section 2064.5b, a postgraduate training license is valid up to 90 days after completion of 36 months of board-approved postgraduate training if the license holder is enrolled in an approved postgraduate training program. This allows the license holder to complete 39 months of approved training before requiring a physician's and surgeon's license. BPC Section 2065G states, upon review of supporting documentation, the board, in its discretion, may grant an extension beyond 39 months to a postgraduate training license to successfully complete the 36 months of required approved postgraduate training. In order to successfully complete 36 months of required approved postgraduate training to be licensed in California, this must include completing 24 months in the same program. Board staff continues to receive license applications from current residents that have not completed 24 months in the same program upon completion of 39 months of training due to circumstances outside of their control, such as program closure. Currently, board staff brings recommendations for these license extensions to the committee for review and approval. However, these types of situations may need expeditious resolution due to approaching license expiration dates. Board staff review supporting documentation provided by the applicant to determine the cause for the applicant not meeting the 24-month requirement and whether or not the license extension would likely allow the resident to continue training in California in order to obtain the physician and surgeon's license. If approved by the board today, board staff will have the authority to extend these postgraduate training licenses beyond 39 months after review of supporting documentation without requiring approval of the extension by the committee. The committee recommends approval to delegate board staff the authority to grant extensions to the postgraduate training licenses pursuant to California Business and Professions Code Section 2065G. This concludes my report. Are there any questions we can answer for you?
This is Dr. Thorpe. Madam Chair, just a question, item of information. Is there, since we still have oversight of this process, is there some process for bringing these, just for accountability for these extensions so that the board will be aware of what the process is and what the pattern of extensions are?
That's a good question. Ms. Webb or Mr. Pacifica, do you have any opinion on what that, how we might close that accountability loop or provide some information to the board about how many of these we see, for example?
I think that it would be appropriate to include the numbers in a licensing report if that would be acceptable to the members.
That sounds like a good idea to me. Thank you.
Christine,
any other questions?
Yeah, I think I just want to give a comment. There's no question. As a person working at an institution with about 180 residents, this is an issue. There are hospitals which close or get sold to the for-profit entities. So those residents get transferred in their third year, sometimes in their fourth year, sometimes in their second year. And it really puts a lot of stress on these young people. Already they're struggling to get the PTL. PTL is brand new, and our staff had tough issues because of COVID on one side and PTL on the other. So I wholeheartedly support what staff is asking.
Thank you. Are there any other questions or comments? May I have a motion to adopt the recommendation?
So moved.
Thank you, Dr. Gananadeb.
Second.
Second from Dr. Thorpe.
Correct.
Thank you. All right, I'm now going to ask the host to call for public comments, please.
Okay, the Q&A window is open for anyone who would like to make a public comment. Everyone, a few more seconds there. Okay, Ms. Lawson, at this time I'm not seeing any requests.
Thank you, Sean. All right, bringing it back to the board. Are there any other comments or questions? Seeing none, Ms. Caldwell, will you please perform the roll call vote?
Ms. Campoverde,
Aye.
Dr. Gonadev,
Aye.
Dr. Hawkins,
Yes.
Dr. Kraus,
Yes.
Ms. Lawson,
Yes.
Ms. Lubiano, Ms. Lubiano,
Yes.
Dr. Lewis,
Aye.
Dr. Mahmood, Dr. Mahmood, Dr. Thorpe,
Aye.
Dr. Toronto,
Yes.
Mr. Watkins,
Aye.
Dr. Yet.
Yes.
I'm going to circle back to Dr. Mahmood. I can't hear you.
Yes.
Thank you.
All right, thank you, Ms. Caldwell. The motion carries. Yes, we did hear you, Dr. Mahmood. Thank you.
Thank you.
All right, moving on to the next item, which is item 21, update on the Health Professions Education Foundation. Dr. Hawkins and Dr. Gananadeb, please.
Thank you very much, Dr. Hawkins. The Health Professional Education Foundation, HPEF, improves access to health care in underserved areas of California by providing scholarship and loan repayment programs to health professional students and graduates who are dedicated to providing direct patient care in those areas. In return for this support, recipients agreed to provide direct patient care in a medically underserved area of California for a period of 1 to 3 years. HPEF is housed in the Office of Statewide Health Planning and Development, OSHPD, OSHPD. HPEF met on January 13, 2021. Dr. Ganadev and I represented the medical board. Elizabeth Landsberg introduced herself as the new executive director of OSHPD. 2 new HPEF trustees were introduced and sworn in. They are Brenda L. Wright and Jacqueline Rangel. HPEF advisory committees. HPEF has advisory committees whose purpose is to assist the program outreach, scoring applications, and providing input on program improvements. We encourage interested persons to visit us at OSHPD website and apply. Please encourage suitable contacts to apply. The advisory committees are 5 in number: advanced practice, allied healthcare, licensed mental health, nursing, and Stephen M. Thompson. Social media. We encourage you to explore HPEF by visiting oshped.ca.gov and search HPEF. For information on loan repayment, scholarship application cycle dates, and all programs, please follow us on HPEF Facebook, Twitter, and Instagram. HPEF programs update for fiscal year 2020 and 2021 includes 3. They are the HPEF loan repayment application cycle for 4 programs. Number 2, the Stephen M. Thompson Physician Corps Loan Repayment Program, and HPEF scholarship cycles, which include 6 programs. I want to emphasize a little bit on the Stephen M. Thompson Physician Corps Loan Repayment Program. This cycle opened December 1, 2020. Its deadline was extended to February 23, 2021, because we received less applicants than in the prior cycle. Reasons included prior applicants moving out of California and a significantly higher loan repayment amounts for the Cal Healthcare Loan Repayment Program. HPEF awards up to $105,000 can be rewarded for up to 2 times, but not all awards are funded to the maximum because it's based on the amount of based on the educational debt still owed. State of California grant proposal. We want to remind you that the State of California grant portal is now open. I'm sorry, I misspoke. State of California grant portal. The State of California grant portal is now open. It's your one destination to find all grants and loans offered on a competitive first-come basis for California state agencies. Please visit them and share this. The address is grants.ca.gov, grants.ca.gov. Again, for all HPEF information, follow us on Facebook, Twitter, Instagram. Please spread the news of what HPEF is and what it offers to your contacts. Investigate our advisory committees, and we invite the public to attend our meetings. The next board meeting is March 24, 2021. And that's the end of my report.
Thank you, Dr. Hawkins. Do any members have any questions or comments?
I'm thankful for Dr. Hawkins. He not only takes the minutes there, he even presents them. Thank you, Dr. Hawkins. And what I would suggest to our staff is send emails to all the PTL residents who got the PTL, and to the young doctors at least, because many of them don't even know we have these loan repayment programs. I think it's unfortunate if we don't utilize the funds, or if there are not enough people. Goal is to have people who take care of socioeconomically disadvantaged people to get primary care. So that's why I think I want to make sure that we get the right people to apply and get those scholarships. Thank you.
Thank you, Dr. Gnanadev. Any other questions or comments from the board members?
Madam Chair, Dr. Thorpe, I just had a question for Dr. Hawkins or Dr. Gnanadev. Are there significant, I guess I'm wondering how much funding is available for this on a yearly basis, and how much goes undistributed?
Dr. Thorpe, I can tell you that nothing goes undistributed. Usually we want some competition. There are enough people there who get. I just can't recall how much funding is. Remember that majority of the funds come from our license fee. Well, when we pay the license fee, there is an additional funding for the STLP program. So that's where it comes from, and some comes from the managed care entities fines. So we can get you the exact amount every year. I just don't have it in front of me.
Yes, thank you, Dr. I don't have that information either, but it was presented in a prior, one of our prior updates, the amount of dollars that are available to the various programs. And we did get as Dr. Gnanadev indicated, our license fees go support Stephen L. Thompson, but we also got a windfall related to the mergers of some of the pharmacies. We are aggressively trying to increase our coffers to continue to support these programs. I would encourage everybody to look at that grants.ca.gov, although we're on that site, but additional sources on that site as well, including one of the major competitors to HPEF, and that was the Cal Healthcare that I mentioned previously, that offers a larger amount of dollars. Again, it's in one of the prior minutes. Also, you can go to the website and you can see our minutes in their entirety, and it's definitely on that website.
Dr. Mahmood, can I speak, Ms. President?
Please go ahead. Thank you.
Yeah. This is a great program. My question is, if there are multiple candidates and there is a competition, what are the priority criteria, people who will get it and who won't get it? Is there any certain guidelines? And number one. And number two, is there any plan in the future to do that people going to the nursing school or medical school, and we can offer them this kind of program before that, and they promise to come back and work in restricted areas, so that might give them more incentive to do it and sign up, and you will have more candidates than just after they've already done.
So the individuals that do the scoring of the applicants, all applicants answer the same questions, and those questions relate to the experiences they've had and the growth and development that led to their desire to participate in this program. And there's questions on that order that help us score the individuals. The scores, individuals are scored blindly, and at the conclusion, the totals are compared, and that's what determines who are offered awards. Now there are allied health, nursing, and physicians programs alone. Some are scholarships. At the present time, we're evaluating how to best get individuals interested in serving in underserved areas. Suggestions like you mentioned are very important. Thanks for mentioning that. We want the advisory committees to do. We want individuals to volunteer for the advisory committees, or just come on and participate at our meetings and offer suggestions such as yours. I'll take that back to the next meeting and speak with our executive director. Thank you.
Thank you. Are there any other questions? All right, seeing none, I would like to open it up for public comment.
Okay, anyone wishing to make a public comment on agenda item 21, please indicate so in the Q&A window, and we'll call you in the order received. Give it a few more seconds there. Okay, this time it's also, I'm not seeing any requests.
All right, thank you. We'll bring it back to the board, and this also is not an action item, so we will move on to agenda item 22, which is presentation on the enforcement process from the board's Chief of Enforcement, Ms. Jones. Welcome to the meeting, Ms. Jones.
Good morning, Madam President, board members. Thank you for allowing me to speak today. My name is Jenna Jones, and I am the Chief of Enforcement. I started with the board in August of 2019. I plan to go over the process. I'm hoping I can address some of the concerns about contact between our staff and complainants, and I'm welcome any questions you may have. So the first slide that we have today is an overview of the enforcement process. This is found on our website, and it's a schematic that goes through the various steps of our enforcement process from the complaint being received to disposition by the Attorney General's office and the board, and then the possible appeal process. It is not a short process, it's quite involved, but I'm going to try to hit some of the highlights today and hit the main points. May I have the next slide? So when the board receives a complaint, we receive these from many different sources. We receive them from the public. We receive them from mandated reporting, such as 801s, which are the malpractice settlements, as well as 805s, which are from facilities when an action has been taken against a physician or a physician resigns under investigation. We also have other licensees that report investigations or complaints. We receive matter from government agencies, including the FDA and the DEA. And then, of course, we do have the anonymous complaints as well. In my experience, we've seen a great number of anonymous complaints involving impairment, which are a huge concern for public safety. And I have, in accordance with the statutes, we find these are prioritized, and we are requesting that they be handled as promptly as possible to determine if an impairment situation exists. Sean, may I have the next slide? When a complaint first comes into the board, it is received by the central complaint unit. This central complaint unit will triage the allegations, and as that case is set up in our system, a letter is automatically sent to the complainant with the case number. At that point, it has not been assigned to a staff member, so it is simply a letter to the complainant advising them that we've received the complaint. They're welcome to submit additional information. It's going to be assigned to a staff member who will in turn follow up with them. Next slide, please. So once the staff member in CCU, the analyst, for you'll hear that term also, receives the complaint is triaged, reviewed to determine what are the allegations. Did the person submit a signed release when they submitted the complaint form? Now, I will tell you we are receiving complaint forms both in letter or paper form as well as online. The online complaint process has been very effective and is used more readily now than the paper forms. A lot of the anonymous complaints do come in from the computer as well, and sometimes those provide a certain challenge because we don't have any information to follow up with, but that has always been the case even when they come in on paper form. So once the CCU analyst receives the complaint, they are going to review the complaint, determine what's necessary to move forward. At that point, they are going to send a letter to the complainant asking for additional information, also advising them that they've been assigned to the case. The letter provides their email address as well as their phone number. At that point, if we don't have releases, the analyst is going to request the release, so we may obtain the patient records and may ask for additional information or clarification on details of the complaint. At that point, once we receive the releases back, we're also going to reach out to the physician and request the records and ask for the treatment of summary. Next slide, please. Once CCU has gathered the releases, gathered the medical records, evaluated if perhaps we need additional prior or subsequent records, or perhaps hospital records, the matter is going to be forwarded to a medical consultant for review. Currently, we are sending all cases for consultant review, and they may be going to, if they're going to an initial review as well as a subsequent specialty review. Once the case is reviewed at that process, if the consultant feels that there is a possible violation, the matter is going to be referred to HQIU for formal investigation. If it is found that there is not a possible violation, the matter may be closed at that point. If there is another possible violation but does not seem substantial enough, we may also choose to issue a cite and fine. At that point, the complainant is also notified as to what is going on with the matter. The complainant is going to be notified if it's going to be sent for further investigation, if it's going to be closed. Next slide, please. The investigation process. This is when, and at this point I'm referring to the formal investigation. This is when the matter is sent to HQIU for formal investigation. We also do have some other cases that may go to our central investigation unit, which is our inside investigation team that is made up of non-sworn investigators. They have done a tremendous job of addressing the 801s, which are the malpractice cases, as well as the subsequent arrest and those type of cases. So we're very happy to have CIO following cases as well as being able to refer them out to HQIU. Now, when it goes to HQIU, this is when the actual investigator is going to request an investigation interview with the complainant. But please understand, in the new process, and I'm not sure how it was handled, but I've heard a lot of comments that the complainants were not contacted or were not allowed to make input. That's not the case now. The complainants are contacted and held a formal investigation if the matter goes to the HQIU step. But all along the way, when CCU is handling it, we welcome input and additional investigation and additional information. So once it goes to HQIU, that's when they have the official sit-down, formalized interview. But prior to that, in current cases, we are having contact with the complainant. Also, when it goes to HQIU, that is when an interview is held with the subject, the doctor, possible witnesses, which may include nurses, family members, other doctors, etc. Once that investigation is complete, they are going to be, HQIU submits their report to medical board. My team and I are reviewing those and determining if the case is going to be going forward to the Attorney General's office, which is based upon the expert findings, or do we need additional investigation, or should it be referred for a cite and fine, or is it submitted for a closure? There are many different outcomes that can take place. Again, the complainant is going to receive notice of what's happening at this stage. If it is referred to the Attorney General's office, they are going to be notified of that. If it's going to be closed, they're also going to be notified. A lot of time and effort is used to evaluate the incoming case, the facts at hand, and whether or not which direction the case should go forward with. Next slide, please. The disciplinary process, as you know, this is when the accusation is filed. This is the initial step, would be the accusation. And then as the case moves forward through the process, we are attempting to interject earlier with these cases and address settlement if possible. We are asking for surrenders very quickly in the process when cases warrant such action. As the case is going through the process, there are mandatory settlement conferences that are involved, and that is when the AG's office as well as our office is involved in discussing possible settlement of the cases. There are cases that cannot be settled early on, and those are going to go to hearing. Once the cases go to hearing, the ALJs, as you know, as panel members, make their recommendations based upon the guidelines, and they have a large number of disciplinary outcomes that are possible. The Attorney General's office is in contact with the complainant during the process and chooses to use them as a witness when possible in the case. We have had cases where the witnesses choose not to participate or refuse. That makes it difficult to proceed with hearing, but the Attorney Generals have taken those cases forward. Again, once the case is resolved and it has gone through the board panel for acceptance or rejectance or modification of the stipulated settlement or ALJ decision, the complainant is advised of the decision. The matter is also disclosed on our website with the disciplinary action taken. Sean, next slide, please. You all have probably seen this diagram before. This is the number of complaints received in fiscal year 19 through 2020. Please understand that the complaints received were well over 10,000 complaints. As of at this point in FY 2021, we expect to be on the same track with the same number of complaints. We did see a slight drop during the initial COVID situation, but the complaints have continued to be steady, and we expect to exceed 10,000 complaints again this year. In this diagram, the investigations that were opened, that would be reflective based on those 10,000 complaints. But the disciplinary actions taken, that 380 number, those are not necessarily from that year's complaints. Those are from a culmination of the cases that were resolved that have been pending with the HQIU as well as the Attorney General's office. So the 380 cases, 3.5%, are not respectively to the 10,008 number. So I'm sure everyone understands that, but I just wanted to point it out. Next slide, please. I received questions, and for those cases where a licensee is placed on probation, I understood from the last board meeting that you all wanted a little more illumination on what that entails. So once a case is referred for probation and a licensee is placed on probation, the probation unit immediately contacts the licensee who has been placed on probation. That licensee is met with by a probation monitor that has been assigned to them and is geographically near that person. With COVID, we did need to start doing these by phone or by Teams teleconference. But as the state has been opening up, we are returning to those in-person meetings. During those in-person meetings, the probation monitor would meet with the licensee and review the terms of the order. Surprisingly, many of the doctors did not understand the terms of the probationary order that they had signed. So we find that this is a very important step for the probation monitor to sit down, go over the details of the order with them and the expectations. They also are going to review the current situation with the licensee, the type of practice they're in, possible mid-levels that they may be supervising or not, and establish due dates, establish the reporting process. If the person is going to be undergoing testing, bodily fluid testing, going over the details of that and how that's carried out. So this initial meeting with the probation monitor is very important, and it's basically establishing the guidelines and the process that probation will be following with this licensee. Next slide, please. Throughout the probation term, this probation monitor will have consistent contact with the probation licensee. This will include on-site visits on a quarterly basis. There will also be quarterly declarations that the licensee will be submitting to the probation monitor. There will be a review of records. These could include records from chaperones, monitors, practice monitors, testing results, etc. Now, I will tell you, we have a special unit that monitors all of the testing on a daily basis. So the testing results are shared with the probation monitors, but due to the impact of positive tests, those are monitored daily by a team here in Sacramento. Now, confirmation of the compliance with the terms and meeting with others to confer that the probation process is being followed falls on the probation monitor. These people are dedicated to assuring that the compliance is met, and there are many steps in the process to assure that that's taking place. Next slide, please. If the probation monitor identifies issues that they have questions on or feel that the probation licensee is not being consistent with or not meeting the standards for the probation process, they will draft a report and submit this report for supervisory review with an outline of what the issue is, what was identified, what the details or supporting facts are. In that review, the supervisor and the probation monitor will then determine, does this rise to the level of a cease practice order? Is it something that can be referred to a cite and fine? Or does it need to be submitted to the Attorney General's office for a petition to revoke? Next slide. In FY 19-20, there were 530 licensees on probation. It is a great number of licensees to monitor, but the monitors are dedicated to supporting that the licensees are following the terms under their probationary orders. COVID did throw some of our processes into a different realm, but I'm happy to report that as the state is reopening, our probation monitors are also returning to the standard in-person meetings when possible, but are also maintaining the video and phone conversations with the licensees when that's not possible. Next slide, please. I appreciate your time today, and I will be happy to answer any questions you may have. Thank you.
Ms. Jones, thank you very much for that presentation. Are there any questions or comments from board members at this time?
Dr. Yip, can I come?
Please go ahead.
Yeah. Hi. Thanks for the presentation, Ms. Jones. Question one is that on average now, how many cases that per the staff, how many cases that they're monitoring on the average? I think a couple of years ago, they're pretty overloaded. The second question is that we oftentimes have CME requirement for the license on probation, like 20 more units every year, and to the area there's a deficiency. Do the monitor always pass on those information to the medical consultant to see whether those CME credit are appropriate for probation licensee?
Madam Chair, Dr. Yip, I will have to get you the number of average cases. I'm assuming that you're asking for the CCU staff. Am I correct in that number?
Yeah, like for example, one staff, I think in the past we monitored 35 or 40 cases. I'm just curious what the current number is.
Madam Chair, Dr. Yip, I do not have that information, but I will follow up and get it to you by Monday or Tuesday.
Thanks.
And then on the CME, yes, we are reviewing the CME that they have submitted as part of their educational courses, and those classes should be in the areas outlined in the order or in the area of deficiency that brought rise to the case.
But who would give the final okay for those CME courses or credit? It's our staff member, or they would consult with the medical consultant from the medical clinical point of views?
I believe the monitor and the supervisor are reviewing those, but I will double check and make sure. I thought the supervisor was approving them with the input of the medical consultant, but I will certainly double check on that for you.
Thank you.
Dr.
Any other
Gardner,
questions, please?
Ms. Jones, yesterday, Kathleen Nichols mentioned something about the anonymous complaints. What's your thought? And you mentioned that they are pretty important to us. So I'm just somewhat conflicted there. So can you explain and how we can also work with the HQIU, because we want everybody to be in the same place so that we can get these timelines down. Thank you.
Madam Chair, Dr. Ganadev, I am very concerned about the anonymous complaints, because a lot of times we're seeing those involve the impairment issues. And as such, impairment cases are imperative that we get those investigated as soon as possible. In respect to Ms. Kathleen's presentation yesterday, I am interested in working with her on trying to triage or set up a protocol for the anonymous complaints they choose to, for lack of better description from what I heard yesterday, set aside. But I do not believe that anonymous complaints should be discounted completely, because they do sometimes have very important information that someone doesn't want, either a staff member or another physician or whomever want to bring forward. So I need to work with her on that and have a further discussion. I quite frankly wasn't aware of that before yesterday, but I am open to discussing it with her and trying to figure out a better way to address those.
So if both of you can put together a protocol and follow that, and if we can make it a presentation to the board at the next meeting, I would appreciate it. Thank you.
Yes, sir.
I think Dr. Thorpe, did you have a question as well?
Just a point of clarification. I just wanted to make sure that I understood this properly. When you're talking about the probation monitor, that's someone in your in the enforcement arm of the board. Is that correct?
Madam Chair, Dr. Thorpe, yes, that is a enforcement employee, staff member.
So that's that, and clearly that's different than the practice monitor, who is another physician that's been assigned to actually do the work of monitoring charts and making sure the workplace looks appropriate and doing the on-site visits as well. That's a totally different issue, right?
Yes, you're talking about two different people, but you've actually got two set of eyes at the practice. You have the practice monitor, who is doing exactly as you said, and we also have the probation monitor, who is also visiting the site to observe, are they working alone? Are they working with others? You know, side-on, hands-on evaluation and meeting with the probation licensee on a regular basis.
Thank you.
Dr. Hawkins, may I speak?
Please.
Thank you, Ms. Jones. It's not uncommon for us when we have to make a decision, whether it's early termination of probation or something, and there's a comment about the quarterly declarations. And sometimes we're told the quarterly declarations were not received timely or they were missed. Could you help me understand how difficult it is to provide these quarterly declarations so we can understand if that's something that we should put in the mix as we try to decide, make decisions about individuals? How difficult are these quarterly declarations to complete, to provide, et cetera?
Madam Chair, Dr. Hawkins, I appreciate that question. I have reviewed that question on some of the cases that I've seen where they've had a petition to revoke, et cetera. Quite frankly, I would like to get some more information on that and see what percentage we have of cases where we have delays, and what the delays seem to be. I cannot provide you a good answer on that today, but I would like to research that further for you.
Additional questions or comments, Ms. Jones?
I have a comment and question, if I may.
Please.
Thank you. Lori here. Thank you, Ms. Jones, for your presentation. One comment I had is that for the enforcement process flowchart that you have up or you showed, I love flowcharts. I think it's a good way to convey information in a brief and efficient manner. And I know you mentioned that was on our website, but what I would like to see is a drill down of this flowchart, particularly with the expert review process, as well as the complaint process, how we close the loop, with, when cases are closed, for example. So I think that would be helpful for me and for the public to see on our website. So that's my one comment. My question, and we talked a little bit about this yesterday when I had asked Bill about it, is with the expert review process and also this closing of complaints, do we have a designated feedback loop on both of those? For example, what are the things that we do to help our expert reviewers, get trained or, check up on them on the way? And then also when we close cases as well, what does that feedback look like?
Madam Chair, Ms. Lubiano, we do have a feedback loop. When the case goes through an expert review, the case is sent to an expert. The expert submits their report to HQIU. That case is sent to the district medical consultant that works for HQIU to see if there's feedback, concern, whatever. The case is then forwarded to us. We're reviewing it. We also have our chief medical consultant involved in some of those processes because some of the cases there's a concern as to whether or not there might be an issue that was overlooked or missed, or is it truly, we have questions and experts have their opinions and they're going to differ. So we have the district medical consultant, which is a licensed physician, providing feedback. Here in our office, we have our chief medical consultant assisting. And then if it's being closed, we're sending a letter and letting the complainant know. And believe me, I hear from a great number of complaints where they feel like something was missed or something wasn't properly evaluated. And I do take a look at those, and we may send those out for a second review. So we are following up on those cases, but we're also having more reviews up front before that decision is made. Also, sometimes the case will go to the Attorney General's office, and they review the case and have issues, and we're having to get a second expert review. So we have seen a great number of cases that may have that process as well. But there is an appeal process, if you want to call it an appeal, but a secondary review process.
Dr. Do a follow-on. I'm sorry.
Go ahead. You go ahead.
It's just a follow on that, Ms. Lubiano's comment. Often we live and die by the experts, so they're really, really important. I'd just like to know, is this district medical consultant, are they involved in various processes? For example, if the consultant has rendered their opinion and there's a question about additional information that's needed, and this is appropriate for the district medical consultant to review it, do they only view it after the experts given their final report, or they have the ability to discuss early on for these complicated cases? And I'm being vague only because we have to be vague. I just want to know, is the district medical consultant only used at a certain stage in the process?
No, sir. Madam Chair, Dr. Hawkins, the district medical consultant is an integral part of the investigation process. When the case initially goes over to them, they're assisting the investigators with identifying additional records that may be necessary. They're also involved with the interviews with the subjects. And then they're also included in helping identify which experts would be best to, or which area of experts would be best to refer the case to. So they're involved through the entire HQIU process, and that's why when the case comes back, it's important for them to also be involved.
Thank you very much. And thank you, Dr.
Dr. Mahmood. May I?
Please go ahead.
On this expert reviewer, the physicians you have, I keep on hearing this thing that have we trained them well and have we got them all on the cases? I think when we talk about our department trained them, they are already biased that they have to make a decision or they have to make an opinion which is more favorable to our case than a standard practice. I personally think that when we get the expert reviewers, we can have their independent training so that when they are challenged, most of the time when they are challenged by the respondents, expert reviewers, they are basically declined. So there should not be that much difference of opinion. I mean, there is always a difference of opinion in medicine, but there should not be that much difference of opinion from the standard practice that 6 or 7 out of 10 times expert reviewer from the board is declined by a standard one. So is there a way we should do that we don't make them biased and let them make the case a real case, so that once we go in any court or anywhere, that is upheld instead of denied or declined after that?
Madam Chair, Dr. Mahmood, I respectfully disagree that we ask them to be biased on behalf of the board.
I'm not saying that. You asked them.
Okay. I just wanted to clarify, and I was having a hard time understanding. We do not. We ask them to give us their opinion of the case. Unfortunately, sometimes the case will move forward with an accusation, and the defense raises issues that perhaps the expert did not consider at the time or fully evaluate. And we do have experts change their minds and take an extreme departure down to a simple departure. I'm not going to lie, that happens. And that is why we are working to refine the expert pool and provide the best experts possible, because that is a loss of time. It's a loss of money for the board to pursue with those cases that may or may not have a departure. So that is a very important fact to us, and it's a very important consideration. We are trying to work on the expert reviewer program. The whole COVID situation has raised a number of issues, but I hope to get back on track with that process this year. But we are refining it. We've reviewed a lot of reports, reviewed a lot of submissions, and unfortunately some of the experts are no longer being used. But we've also brought a lot of new ones on board. So I'm hoping we can flesh it out and have the gold standard that the expert pool deserves.
Thank you. I did not mean to say that we intentionally bias them. I meant to say that when it comes from the board's perspective, it's an implicit bias in their mind. That's what I meant. But I don't mean to say at all that we are trying to convince people to go and do this for us. Thank you.
Thank you. I apologize for my misunderstanding.
Hey, Jenna, this is
Additional
Watkins.
questions or comments?
TJ Watkins.
Mr. Watkins.
Yeah. I just have two questions, Jenna. First of all, you're doing a great job in managing this department. My question has to do with the customer service part of this job, because we've heard a lot of complaints, via on the calls about not enough notification of the different parts in the process. So according to what you just walked us through, I made a few notes that I'm just going to focus on that 3.5%, the 380 for the 1920 financial year. So for the 1920 financial year, that means the board, from just our part, we would have issued 5 letters to every person, to each of those 380, if the procedures are followed. So my question is, are we following that procedure?
Madam Chair, Mr. Watkins, absolutely. We should be sending, at each point of contact, we should be contacting the complainant. And if they're reaching out to us in the interim, we should be responding to them.
So do you think it would be possible in the quarterly report that I'm going to put together with Mr. Pacifica, and obviously you yourself, that we could include those that we've sent out those letters? The reason why I'm doing that and making that request is because this is where the public trust really wanes for us. Because we hear from online and from everybody calling in that the board didn't contact at all at all these various stages. And now you say the complete opposite. You point out to 5 stages that the board is communicating with the complainant witness or the complainant. And then on top of it, if it goes to the DAG has 2 more opportunities to speak and interact with him via letters or updates. And we are responsible for the final bit, where the case is decided and they get a letter from us that's saying, we couldn't win that case, or whatever the justification are. Because if we follow the procedure, we should have 1,900 for the 1920 year, 1,900 letters on file. Now, I'm not going to go into the past because it's pointless to do that. What I think what we need to do is have this be a verifiable practice, since this is the thing that it gets pointed out to us that creates public distrust. And one of my goals is to rebuild the trust. And I'm sure that's your goal too, because you've been working so hard to bring all these numbers online. Your concerns are real. And I just want to help with that process, because as you are efficient in actually conducting the job, there is another component, which is the customer service component. And that means the complainants, some of them were harmed in the incident. So they're dealing with the grief, they're dealing with the pain. If they don't hear from us, someone said they feel an institutional betrayal. And I thought about that and I said, yeah, sometimes even in our own life, when someone doesn't communicate with us, we get our feelings hurt. Now, what if you've been hurt in real terms? So that's my motivation. My real sincere desire is to just build the public trust in this board. And that means we need to produce then the kind of numbers that makes it irrefutable that we're doing everything that we can. And I know you want to do that too. So I'm very grateful for your work. Thank you.
Thank you, Mr. Watkins. I agree with you. I do want to build the trust. Unfortunately, I will say that sometimes the complainants will receive our letters and call us and want to talk to the medical consultant or and we can't have that level of disclosure with them, but we do discuss that, either the medical consultant didn't find or the expert didn't find enough evidence for a clear and convincing case, et cetera, or find a departure. So I will be happy to work with you on that. And I too would like to address that issue, but because I think the communication is very important. And that's what I wanted to point out today, is that we are having several levels of communication. Years ago, I'm sorry, I don't know what their process was, but I am looking forward. So thank you for your input.
That's exactly what I want to hear, that we're looking forward and we're going to do better, because I'm seeing that in your work, that you're doing better. You have a positive forward-looking attitude, and I really appreciate that. Thank you.
Thank you. And it's the simple things, just as getting the initial complaint set up with in under 10 days. I think that you're seeing on an average now we're at 5 days. A year or two ago, those were at over 18 days. So it's the little steps, and it's going to take time. So I appreciate your patience and I appreciate your support. Thank you.
Thank you. Are there additional questions or comments?
Madam President, I have one. Alejandra?
Please.
I'd love to ask a question about the opposite end of the spectrum, which is the thousands of folks that received letters that their case it was closed, their case was closed. So when these letters go out, and I appreciate that some people will call and follow up, but many will probably be very sensitive and emotional, not make that call. How much detail goes into the reasoning behind the closure? I understand that there's sensitivity around that, but when someone receives this letter, does it just say that it's been closed? Is there a reason given? Can you speak to that?
Yes. So a lot of the letters, quite honestly, don't have a lot of specifics about the case. It talks about the case was reviewed by a medical consultant who did not feel that so depending on the stage that the matter is closed is going to dictate the letter that goes to the individual. Of course, if a case has gone through the investigation process and the expert did not find a departure, that's going to be something else. Some cases are closed after they've been reviewed by the Attorney General's office. And so it just depends on the stage in the process as to which letter is sent. But I will tell you, the details about the specifics of that case are not in the letter. It's more of a generic, we couldn't rise to meet the clear and convincing, the expert didn't find any departures, etc. I hope that helps.
It does. So to TJ's point, I think this would also be a great opportunity as far as communication with the public to rebuild that public trust about the sensitivity around how this is communicated, again, within the range of what's acceptable. But that language, I think, is something that would be worth looking into as well.
Yes, and I believe that the letters were recently revised, I want to say back in 1819, and we continue to look at those. But of course, I don't have a problem looking at those again and seeing what we can do.
Dr. Yip, come in. Dr. Yip, can I come in? Yeah, actually, I asked the same question a few years back, and one of the issues is that we cannot be too specific. For example, we can say, well, medical concern, few this, say that, because that information can also be used by the complainant in the legal cases, that the medical opinion would be quoted in those cases. I think that was the explanation was given at the time. But you're right, we try to be more sensitive. And I think Jenna did a good job, so even some verbal communication that give comfort to the people who complain too. So there was some limit what we can put down on those so-called form letters. Thank you.
Additional comments or questions? All right, I'd like to ask Sean to open up the Q&A for public comment, please.
Okay, anyone wishing to make a public comment on agenda item 22, please indicate so in the Q&A window, and we'll call on you on the order received. First up here, we have Kathleen Nichols. Kathleen, are you there?
Yes, can you hear me?
Yes, go ahead.
Yes, hello, Kathleen Nichols, Deputy Chief with HQIU. I just wanted to clarify my comments from yesterday. I believe I did state that any cases involving impairment, whether anonymous or not, should still be investigated and looked into. And not only just impairment, but anything relating to patient harm should be addressed. My comments were relating to the rest of the anonymous cases that we get. So I look forward to working with Chief Jones, developing a formal criteria for that, but I just wanted to clarify that. Thank you very much.
Thank you, Kathleen. Next up, we have Eric Andrews. Eric, are you there?
I'm here.
Please go ahead.
Okay, I have to talk really fast. I have a lot to say. Boy, this one got my blood boiling. I hate to burst your bubble, TJ. I can prove why we distrust Jenna Jones and the enforcement department. Complainants can't even ask if their so-called expert is qualified or has conflicts of interest. Alejandra, we have cases that were closed and then the victim won a lawsuit against the doctor and the board had to reopen the case with their tail between their legs. These reports from your staff are often ridiculous. How many of you sat there and just accepted everything Jenna said as truth and intend to move on without giving it a second thought? She clearly has no clue what's happening in her own department, and now she's inferring that victims are liars. How dare she say that complainants are kept in the loop the whole time and allowed to make statements? That's just bullshit. They can recite this dry procedural information to you, but that doesn't in any way mean that it's actually happening. On the schematic she showed, it clearly says, if more information is needed, the complaint unit analyst requests it from the complainant. If, in my experience, they never feel they need more information at the point and no one is ever interviewed. Now pay very careful attention to this. I've submitted a number of complaints on behalf of the Patient Safety League of late, and all of them were automatically closed. No one interviewed me. No one sent me a letter asking me for more information. I merely received a letter stating from an Erica Calderon staff services manager that I was abusing the online complaint system. Now think about it. Have I ever brought a case of a bad doctor to you that was an abuse of the system? So now all of those complaints have been closed. You're accusing me of abusing the system and all of those doctors are walking free. One case's reference is Dr. Paul Sissick, license number 73470. I ask that you look him up on Breeze, which is totally clear, and then look him up on our website, which shows his illegal activities going back as far as 1987, including speeding convictions, charges of making annoying phone calls, felony stalking, and DUI with enhancement. Then in November of 2019, he was charged in Santa Barbara court for assault with a deadly weapon, driving under the influence of alcohol, driving with an alcohol level greater than 0.08, and an enhanced charge of driving with an alcohol level greater than 0.15. He was sentenced in September, case 19CR.
I have to break in here. Number one, your use of foul language is inappropriate and won't be tolerated. Number two,
free speech, Carrie.
Number two is that there are cases in different processes along the enforcement timeline, and I'm going to have you stop talking about this current situation.
So I
if
can
you can't follow this, if you can't follow this process, Mr. Andrus,
it's free
your time
speech,
will be
Ms.
terminated.
Webb. It's free speech, Ms. Webb, and I want my time back.
You have been advised
he was sent to jail for 180 days.
Discussion on current cases. I'm telling you that discussion on this matter.
How are we supposed to know if it's a current case or not, Terry?
Because I'm telling you.
You did not tell me. You said there could be cases. You said there could be cases. That does not tell me whether this is a current case. Is it a current case?
There's information that cannot be revealed at this time.
Then I can speak on it because I don't know that it's a current case. This is the doctor that.
Please cease it. Thank you.
Next up, we have Marion Hollingsworth. Marion, are you there?
Yes, I am.
Please go ahead.
Thank you. Good morning. My name is Marion Hollingsworth, and I'm a patient safety advocate. I would like to thank Jenna Jones for her presentation with the board's enforcement system, but I'm confused as to her explanation of that 3.5 disciplinary rate. So it is 3.5, but then again, it isn't. I would hope you would clarify how you reach this figure again. We advocates use the basic math to get that same figure, and your report corroborates that. Board members should know that this is the lowest it's been in a number of years. Usually the rate is from the mid to high 4%. I was surprised that yesterday Mr. Pacifica was so cavalier about this low rate. Yesterday, he said that California's rate is similar to other medical boards in other states and countries. My reaction to that is that it's appalling that so many boards are content with such a low rate of discipline. This complacency results in more patients being harmed by dangerous doctors and more harmed patients never seeing their doctors held accountable. Is the budget really the driving force for the board's enforcement policy and not patient safety? A much needed audit of the board would sift through all these doctor complaints and see how they are really being investigated. And regarding your investigators, I was told that it is the duty of the board to keep doctors in practice for as long as possible. When I asked her about patient safety being a factor, she said, oh, that too. As I mentioned yesterday, it's surprising that the doctors who were part of the confirmation hearing were unaware of the board's low disciplinary rate. One doctor assured the Business and Professions Committee that the 5% rate that someone else mentioned was wrong, and it was more likely around 8%. It was a lie and a gross exaggeration to tell state legislators that the board is more proactive in protecting Californians from dangerous doctors than it actually is. As I said yesterday, I encourage all board members to memorize these basic enforcement statistics so that when you are asked, you can answer truthfully and accurately. Thank you.
Thank you for your public comment. Next up, we have Christina Hildebrand. Christina, are you there?
Yep, I am. Hi there, Christina Hildebrand from Voice for Choice Advocacy. I am again going to take it from the flip side, which I completely agree with all the other comments. However, when it comes to vaccines, and vaccines seem to be a toxic, it seems to be a toxic word, but when it comes to vaccines, there are anonymous complaints that are filed by, we know from Public Records Act requests that are filed by school nurses, other doctors that are basically out to get doctors that are treating patients with new research. So not using standard of care, and are filing complaints against these doctors just because they don't like the fact that these doctors have written medical exemptions and they don't feel that they are necessary. Usually a complaint comes from either a family member or the patient or somebody that doctor has worked with. For example, if it's a sexual assault case, they don't come from anonymous people that have nothing to do with that doctor's patient care. I know that since 2019, implemented this year, SB 276 has gone in place, which changes the medical exemption process. And we actually will have 0 medical exemptions in this state unless it is from a doctor, for example, that has children on chemotherapy drugs. But other than that, there will be no medical exemptions for children who have had even anaphylactic shock to one vaccine, because doctors are just too scared to write medical exemptions. That's what the medical board has done. You have basically placed a witch hunt on these doctors. They can't use their best practice. They can't use their best judgment anymore. They are being the ones that were willing to take longer time in assessing these children who have been vaccine injured and even gone to the vaccine injury court. Will no longer be able to get medical exemptions, and it's all because of the medical board and these anonymous filings by people who have nothing to do with the case, but yet the case gets followed up on because the word vaccine is in there and the word medical exemption is in there, and for some reason you guys can't seem to take that as anything else other than a toxic subject. Thank you.
Thank you for your public comment. Next up, I have Monique Hims. Monique, are you there?
Yes, can you hear me?
Yes, we can. Please go ahead.
Okay. My name is Monique Himes, and I am from Californians for Quality Healthcare. We have a maternal health crisis in Kern County. There is one particular doctor in Bakersfield who you know has been harming young mothers and babies for 25 years. You have allowed him to continue to harm mothers and babies by giving him probation following the deaths of 2 babies and putting him on probation again for the death of a 23-year-old mother. Pregnant mothers in Kern County are scared. This has caused us to build a campaign in Kern County to educate young mothers to engage in their own health care. Why did we have to do this? Because you are not doing your job. Following the death of a young mother, you offered this doctor a settlement deal instead of him to stand before an administrative law judge For another death, you gave him probation. The problem is that he is breaking his probation. He was given patient notification as a condition of probation, and he is not following it. Young mothers have come forward and informed us that he is not existing patients, and he is not notifying new patients at the time of their first appointment. Your probation monitor is ignoring complaints of his breaking probation. You say consumer protection is paramount. Your actions show that you don't care that our mothers and babies are dying. How many mothers and babies have to die in Bakersfield before you do your job? Thank you.
Thank you for your public comment. Next up, we have, I'm sorry, the name's getting cut up here. Nicole, are you there?
Yes, I'm here.
Please go ahead.
Okay, so this doctor that Monique is talking about is on probation based on Celeste Ortiz's death. This doctor did the same thing to me. Celeste died, and I got to live to tell my story. My name, again, is Nicole Escalera, and I'm a mom of 4 and a police wife, and today is my 27th birthday. Because of Dr. Park and his choices to not practice evidence-based care on November 27, 2013, when we were excitedly preparing to bring our daughter earthside and celebrate her birth, I could have lost the chance to ever celebrate my birthday again. My story is almost exactly the same as Celeste, except I didn't die. The medical rape I experienced at the hands of this doctor is something I wish on no one. If I had died that day, I would have missed all my daughters. First, I wouldn't have had the chance to bring my other 3 children earthside. I wouldn't have had the chance to help my husband through the police academy or pin his badge at his ceremony. A healthy mom is just as, if not as important as a healthy baby. We need both, and we deserve both. The care I received, or the lack thereof, from Dr. Park pushed me away from what birth traditionally looks like in America. I had 1 more baby in a hospital and then 2 at home with my midwife. My midwife never fat shamed me or cracked inappropriate jokes. She also never broke my water in her office, sent me to the hospital for induction, and forcibly removed my placenta or forcibly shoved her hand at my vagina immediately after I pushed out a baby. I think that we could do better. Thank you.
Thank you for your public comment. Next up, we have Tracy Dominguez. Tracy, let me find your line. Tracy, are you there?
Yes, I am. Can you hear me?
Yes, please go ahead.
Okay. My name is Tracy Dominguez, and I am with California. Oh my God, healthcare. You have allowed doctors to continue to harm young mothers in Bakersfield County for 25 years. You have given this doctor probation for the death of 2 babies, and you have given him probation again for the death of a 23-year-old mother. What you did not disclose is that you briefly suspended his license for the death of another mother and 2 babies. Pregnant women are scared in Bakersfield. Since you won't do your job, we had to set up a campaign to educate young mothers in Kern County. They have rights too. Women began to inform us that this doctor was not, and I'm saying not loudly, notifying his patients of this probation that is required. I have complained to your probation monitor, and she ignored my complaints. I continue to complain about this doctor breaking his probation, and she tried to tell me it wasn't her job. She tried to deceive me about his patient notification requirements, but I have read your public documents. I am well aware of what his probation requires are. His probation is well known in Kern County. The problem with the probation monitor is that she was publicly supporting another dangerous doctor in Bakersfield and vouched for him in his attempt to terminate his probation early. She told the administration law judge that he had humbled himself in the process and should have probation, his probation should be terminated. Now we have her. She is not monitoring this probation of this doctor who is harming women and babies for the last 25 years. We will no longer accept your words of consumer protection is paramount. Words mean nothing without action. He is breaking probation, and your probation monitor is doing nothing. The deaths need to stop. We need answers. We deserve answers. Thank you.
Thank you for your public comment. Next up, we have Michelle Montserrat Ramos. Michelle, are you there?
Yes, I am. Can you hear me?
Yes, please go ahead.
Good morning, board members. My name is Michelle Montserrat Ramos, and I'm with Consumer Watchdog. You have heard from 3 brave women who have stepped forward to share their grief and the grief of an entire town. I know your executive director and PIO are well aware of the campaign the advocate moms are describing. One part of the campaign sent letters and emails to their state legislators. The other part of the campaign sent 5,000 petitions to you, the medical board. Dr. Thorpe and Dr. Gonadev spoke of how much heat they took in the Senate Rules Committee hearing on Wednesday and how aggressive the senators were. Well, the advocate moms have the attention of their state senators, and their state senators are not happy with your response. These advocate moms are serious about this issue. The grief of an entire town is in your hands. You may say that a complaint does not belong to the complainant. Well, the death belongs to the complainant. And when you continue to give a dangerous licensee chance after chance, and the deaths continue, the complaint begins to belong to the entire town, and that is the situation you have here. We may be talking about Kern County today, but you know that this probation monitoring issue is not just an issue, a Kern County issue. In 2018, almost half of your disciplines resulted in probation, and now we find that probation monitoring is not occurring. The system's broken. By the way, I have to add, the advocate mom whose granddaughter's case is based on this probation never received a letter that this doctor was placed on probation. And in addition, she cannot get on this call at all, by phone or by online. Ladies and gentlemen, this is a sunset year. You can take care of this issue now, or we can take it to sunset review. Personally, my bet is on these advocate moms. They will not stop. I highly recommend that you listen to them and take action on this licensee, or we will just have to deal with probation and probation monitoring as another issue of sunset review. Thank you.
Thank you for your public comment. Next up, we have April Manott. April, are you there?
Yes, thank you. I was just wondering, April Manott from the Senate Office of Research, I'm just wondering if there's data available for that very handy flow chart of the case process that talks about sort of the individual or typical timeframes that a case would be involved in any of those steps, just to see which parts take longer and which parts are more efficient.
Ms. Jones, I'll ask a follow-up because this is not a Q&A between the commenters and the board or staff members. So I'll ask a follow-up on that question during board member comments.
Okay, thank you for your public comment. Next up, we have Jeff Rizzo. Jeff, are you there?
Yes, I am.
Please go ahead.
Thank you. So you took away Eric's time, which is a violation of the Open Meeting Act. So I'll continue. That doctor was one that your staff closed Eric's complaint by stating that he was abusing the system by submitting a complaint on him. That was back in June of 2020. So you allowed this dangerous doctor to practice 8 months just since you were informed about him, and a lot longer than that. His sentencing is public information. Think about it. How is that you doing your jobs? This is the board being punitive against someone, and so patient safety is out the window. How many of you, other than TJ, care about this and will follow up to find out why and ask about these policies to ignore him and close every complaint he files? He can send you the letters accusing him of abusing the system. It's a sad state of affairs when the public cares more about patient safety than our own medical board. You can't expect the public to know pending cases that don't appear on Breeze.
Okay, thank you for your public comment. At this time, Ms. Lawson, I don't see any other requests in queue.
Thank you. I'll bring it back to the board. Ms. Jones, just to follow up on that specific question, I think it was about whether there were data that we had available that showed where a complaint is at in the process, kind of how many complaints are where, at which stages in the process. Is that something is that data that we have that we can maybe share at the next meeting?
Madam Chair, Madam President, there is a matrix that Mr. Pacifica has begun tracking, and we are following that, and it shows the cases and the age of the case in each step of CCU or HQIU. I apologize, I don't know the exact page of the matrix. It was discussed yesterday, but that will show you the age of the case and which step of the process that it is in, whether it's in CCU, HQIU, or with the Attorney General's office.
Yeah, it is in section 6, and I'm not sure if I have the right. There's an enforcement timeline matrix on board page 6B11, just for the commenter's benefit, and I'm not sure if that's exactly the right page that would be helpful to her, but it would be worth just looking at that item 6 of our agenda, which is available on the website. Are there any other questions or comments from board members?
Dr. Hawkins, may I speak?
Please go ahead, Dr. Hawkins.
Thank you. So, don't want to create any issues, but whose responsibility will it be to follow up on this advocate mom situation regarding if a physician is inappropriately not giving notice?
That would be the probation, and I will check into it after this meeting.
That would seem to be really important. Yes, thank you.
Madam Chair, Dr. Hawkins, thank you. I had the same, Dr. Ganadev, I had the same question. There is a probation monitor who is supposed to monitor all the probation conditions, including patient notification. So, Ms. Jones, can you please make sure that we are checking on it?
Yes, sir.
Thank you.
Any other questions?
Yeah, this is TJ Watkins. I'm gonna second that because it is clear that there's an outcry out of Bakersfield for what is taking or alleged to be taking place in Bakersfield. And I would really appreciate if our enforcement staff, the probation, take the time. There's a lot of pain there, and we have a hand in kind of addressing some of those issues with them. That's part of our responsibility. Thank you.
Alejandra, I'd also add that if it's not on record that all these complaints have been filed against the probation disclosure, that they also be on record.
Additional comments or questions? All right, hearing none, we will move on to our next agenda item, which is agenda item 23, update and possible action on revising guidelines for prescribing controlled substances for pain. And this one, Mr. Pacifica, you're on.
Okay, thank you very much, Madam President. The board has before them a note in relation to agenda item 23. I will simply speak very briefly to it. No one needs to be reminded that the issue of the prescribing of controlled substances is a very core issue for the board, and it has been for some time. It is a matter of continuing importance in both discipline actions and also in terms of setting general policy levels. From my own experience, I can tell you that yes, there are doctors who engage in very poor prescribing practices, but for every one of those doctors, there are maybe 10 doctors who are put under extreme pressure with threats and with the There have been cases I know of assaults of doctors pressuring them to prescribe substances which they should not do. So what is needed is clear guidance. And our own guidelines were last put in place in 2014. And what clearly has happened is that there's a lot of things that have happened since that time. We've listed just things we've done from just a sort of desktop exercise at the national level. And obviously, this only captures a very small portion of it. Even in our recent contacts with some of our stakeholders, we had a conference with the conference call with the California Society of Addicted Medicine. California Society of Anesthesiology reached out to me wanting me to talk at their conference, at their spring conference. And everyone has done something recently. Everybody has updated their guidance. And so I think that the 2014 guidance was very welcome at the time, but I think everyone can understand that a lot has happened since that time. And the one thing that I'm very anxious to say is that I think that by updating the guidance, which will be a very comprehensive process, we will reach out to stakeholders in a very structured way. Within California, there is a huge amount of expertise, a huge amount of interest. It's important that we engage with them. This will not be a quick review. This will probably take us 18 months to 2 years from inception to completion, but I think it is a very sensible and a prudent use of our resources that we focus on a revision of the guidelines, and of course the staff will support the project in any way possible. So what we're calling to do is to set up a task force to undertake what we think is a very important project.
Are there any, thank you, Mr. Pacifica, are there any questions or comments from the board?
Madam Chair, it's Dr. Thorpe. I agree with Mr. Priscus. I agree with staff's recommendation. I think it is a very prudent step to update the guidelines. And if it's appropriate, I'd certainly like to be part of that process.
Thank you, Dr. Thorpe.
TJ Watkins. I would also, hi, this is TJ Watkins. I would like also one of the presenters, Dr. Waller, who was present, who gave the presentation at our last board meeting. I would request that he also be consulted. He had some really interesting, improved approaches that is more cooperative. And he seemed to have great insight. I listened to his YouTube videos, great insight in how to address this problem from a holistic point of view. And if we could capture some of that within the guidelines, I think we will both remedy the rehabilitation part of it and in the process make a better physician, pain physician. So that's my input. Thank you.
Thank you. Additional comments, questions?
Madam President, does it need a motion?
I don't think we need a, well, actually, that's not true. I do think we need a motion. Well, I guess I'd ask Ms. Webb, do we need a motion to delegate to the board president to appoint a task force to address this issue and provide direction to staff to undertake a review of the guidelines?
I would recommend it because it is quite a lot of use of resources, and so it'd be good to have the full support of the board to move forward.
Great, thank you. So, Dr. Gananova, we do need a motion. Yeah.
May I add one comment that the motion is appropriate to approve the task force, but then the assignment of 2 board members to that task force is at the discretion of the board president.
That's true.
Agreed. That's my motion is what Dr. Howard said. Dr. Krause said it's to have a task force appointed by the board president, working with the staff, look into this matter. on improving the guidelines.
Great. Thank you, Dr. Ganadev. That's, I'll take that as a motion. Second.
Second. Hawkins.
Second.
Thank you, Dr. Hawkins.
Also comment.
Additional discussion, Dr. Yip?
Yeah, I just want to point out Dr. Torito is anesthesiologist. In case to try to volunteer her task force at the moment too. Thank you.
Excellent. Yes, let's move to public comments, then we'll bring it back to the board.
Okay, the public comment window is open. If anyone would like to make a public comment, please type in the Q&A box. We're on agenda item number 23. I'll give a few more seconds here to see if anyone queues up. Okay, this time I'm not seeing any requests.
Thanks, Sean. So returning the matter to the board, we do have a motion and a second. I would invite those of you who are interested in serving on the task force to just send me a note offline, and then we can have a conversation. We'll get that up and running shortly. And so I think unless there is further discussion or comment, we're ready for the roll call vote.
Ms. Campoverde?
Aye.
Dr. Gonadev?
Aye.
Dr. Hawkins?
Yes.
Dr. Krause?
Yes.
Ms. Lawson?
Yes.
Ms. Lubiano?
Yes.
Dr. Lewis?
Aye.
Dr. Mahmood?
Yes.
Dr. Thorpe?
Yes.
Dr. Tirado?
Yes.
Mr. Watkins?
Aye.
Dr. Yip?
Yes.
Thank you.
Ms. Lawson?
Yes.
May I just clarify and ask that those individuals interested in serving on the task force to please send an email to Mr. Prosifka. That way we avoid conflicts with the Open Meeting Act.
Fair enough. Perfect. Thank you for that clarification.
Thank you.
All right, we are moving on to agenda item 24, presentation from the Board of Registered Nursing on AB 890 from the Executive Officer at the Board of Registered Nursing, Ms. Melby. Welcome.
Thank you, and thank you for having me. On the screen is a PowerPoint. It outlines 890. I'm sure that you guys are very much aware of what is going on with 890 and what 890 requires of our board. So I don't want to waste a lot of time on going over that. So you guys will have to bear with me saying next slide as you guys are managing the presentation. So next slide, please. So this bill was assigned into law the fall of last year and started in January 1. Our intention is to have regulation promulgated as quickly as possible, with the due date being January 1, 2023. Next slide. So these are some of the provisions that are out there. The first one is to establish a nurse practitioner advisory committee. I'm sure that you guys have seen on our website, there is a publicly noticed meeting that will be held next week, where the advisory committee members are being appointed, and the board will vote on whether or not they accept those appointments. And then we will move forward from there based on the outcome of next week's meeting. Go ahead and you could switch to the next slide. Again, this just clarifies some of the basic recommendations within that bill. Once the advisory board is established, the advisory committee, I apologize for that, is established, they will begin working on the regulatory language, the review of the bills, the review of our current regulation, and work with that. Our legislative office at the BRN has already put together a crosswalk, and we are working really hard to create a very thorough and robust implementation plan. Our hope is to present that implementation plan at our regularly scheduled board meeting that is scheduled for this month as well, and that would be February 17th. Let's go ahead and transfer the next slide. One of the big things that they're going to be focused on is the transition to practice. That seems to carry a lot of attention with it. We did have an APRN committee meeting yesterday where discussion was started with the transition to practice, and they will be providing recommendations as well to this committee because they are serving in a role right now as kind of an interim committee while the next committee is waiting to be established. Would you go ahead and switch again to the next slide? We did, sorry, one back right there. Thank you. We did take a look at the information that you guys have up on your board website for 805. We are taking that as a guideline, and we are creating a section onto our website as well that would allow for 805 reporting. And we are outlining that process. It is in a production mode and it has not been published yet, so it is not live. Next slide. So this is just going to be a brief overview of our implementation plan. I did discuss a lot of that earlier because it is very kind of high level, executive level. So we'll have you switch to the next page. So when we did, we were very much aware that this bill was coming. We did know that it was signed, and immediately upon signing, before the implementation of the bill, we did go out and start the process of creating the advisory committee. So we did put out an application, we did receive out a notification, and different this time than in the past is we did send out every single, we'd sent this application and notice out to every single licensed nurse practitioner that we had in our data bank. We did also share it with your board to send out and shared it out on social media. With that, it did render a lot of applicants. We did receive over 300 applications to be reviewed and processed for the committee. That to me just showed the amount of importance that this is carried. And so it was exciting for that. However, it did cause a delay in us getting the advisory committee in place. Our original plan was to have the advisory committee in place before the January implementation date, but we are now about a month delayed in that. So our plan and hope is that our board will approve the appointments on the February 9th meeting. Once that is done, we will put them through a BMOT is what it's called. It's the board members orientation training. There is one coming up in March, and so we're hoping to get them scheduled for that March meeting, get them trained, and they will be ready to go quickly. Good. Advance to the next slide. Once that's done, we will work on promulgating the regulation. We are waiting for complete evaluation from OPS on whether or not an additional test is needed prior to the transition of practice. And so we will continue to work on the language and in conjunction with that, and we will not be waiting for that evaluation to be done completed prior to working on the regulatory language. So we will work with them side by side. Yeah, next slide. With this, we do know that there will be some IT development that will need to be created right now. If you go onto our website at rn.ca.gov and do a license verification check, you can pull up information on our licensed RNs and nurse practitioners and other advanced practice RNs. So right now it states that they're an NP. So our thought is that once the transition to practice regulation is completed, that there will be a section on our license verification that would state whether or not this NP has successfully completed that transition to practice. And then that would be how the public would be able to identify which NP can practice in the more independent manner than the other. We'll go to the next slide. And those are our resources. I know it's a very short presentation, but I wanted to allow for ample time for question and answer from the board members. And you could go to the next slide. I believe it's just a question or contact information for me. This is on our website. There is no secret here. So if you guys do need to get a hold of me, you can. That is my email and my office number. So you guys can reach me at that point.
Thank you, Ms. Melby. Are there any questions or comments from board members?
Madam President, Mr. Melby, this is Dr. Ganadev. So I just want just a comment, make sure that you work with our staff at medical board because this is a brand new entity for you with some independent practice. So any which way our board can help you, will help you. Thanks for coming.
Thank you. You're welcome. We will have some stakeholder meetings set up where people can come in and provide comment. And then I do plan on continuing to participate in your board meetings to give you updates as we go through this process. I want this to be a very public and transparent process. And since your meetings are publicly noticed, this is where we will provide the updates to you.
Hello, this is Dr. Lewis. I'd like to know about your advisory. I'd like to know about your advisory committee. What is the makeup of that committee and how are they selected? And do you have physician members on that committee?
So I will answer what I can, as the advisory committee is not formed as of today. So what we did is we went strict from the statutory requirements. The statutory requirements requires 4 NPs, 2 physicians/surgeons, and 1 public member. So our plan is that on the 9th, so in just 4 short days, that the board will appoint and vote on appointing those members that would make up that advisory committee. On our website on rn.ca.gov, there is a meeting agenda with materials that will be, I believe, posted today that have the names of the appointees, and you could see what their professions are and whether or not they're an NP, a physician surgeon, or whether they're public member.
Thank you very much.
You're welcome.
Additional comments or questions? All right, seeing none, let's, Sean, open it up for public comment, please.
Okay, the Q&A window is open for public comments on agenda item number 24. If anyone would like to make a public comment, please type yes or anything into that box, and we'll go ahead and call on you in the order received. Okay, first up, we have Yvonne Chung. Yvonne, are you there?
I am. Can you hear me?
We can hear you. Yes, please go ahead.
Thank you. Yvonne Chung with the California Medical Association. Thank you to Ms. Melby for her informative presentation and for the BRN's commitment to engaging in the implementation process in an open and transparent manner that clearly adheres to the requirements in statute. We have been active and we are looking forward to participating in the BRN's process and providing assistance and input. Thank you.
Thank you for your public comment. Next up, we have Cynthia Jovanov. Cynthia, are you there?
Hi, yes, thank you for having me. My name is Cynthia Jovanov. I am a nurse practitioner, a public member, and I actually was on the phone call yesterday with the BRN, making sure that I stay engaged in my practice and informed. In regards to the discussion that Dr. Lewis brought up, which is actually very concerning, was the NP advisory committee that was selected. There was 300 applicants. There is no transparency in regards to the selection. In review of the people who have been tentatively vetted and nominated, the only concern is that 2 of the members come from one academic institute in San Diego that also represents the president, Michael Jackson. So that will make one board member, 2 NP committees that are acute care board certified. And the other 2, there is not much transparency on how they were selected. The concern is that the NP advisory committee remains equal in regards to how they are currently practicing. So making sure that they are in primary care, board certified, psych, acute care, board certified as well. And so my only concern is that the meeting was brought up on February 9th, and I just want to make it known to both public members, those that are practicing as an NP, those that are a physician as well, that it is transparent in regards to the selection process of over 300 applicants. Thank you for letting me voice my opinion.
Thank you for your public comment. At this time, I do not see any additional requests in queue, Ms. Lawson.
Thank you. We'll bring it back to the board. Are there any other comments or questions? All right, moving right along, we'll move on to agenda item 25, which is discussion and possible action on implementation plan for AB 890. And Mr. Bone, you're up.
Thank you, Madam President. I'd like to draw the members' attention to page 2 of the paper for item 25 and just quickly review the proposed next steps for the board's involvement in the process that Ms. Melby laid out, and just again express my appreciation to her for her time in joining us today. One is to monitor the committee Ms. Melby described and BRN meetings for action items pertaining to AB 890. 2, to consult with the president and vice president on developments in between our board meetings and determine whether off-cycle meetings are necessary. 3, to place on future board meeting agendas pertaining to proposed regulations or other materials related to AB 890. 4, evaluate whether our board needs regulation or policy changes related to AB 890 and advise the board at future meetings. 5, work with the Board of Registered Nursing on joint communication efforts that support consumer protection and licensing awareness of the impacts of the bill. And 6th, finally, invite, as Ms. Melby indicated, invite her to future board meetings to provide updates on their progress. I'll turn it back to you, Madam President, for discussion and possible approval. Thank you.
Thank you very much, Mr. Bone. Are there questions or comments from the board members?
Madam President, to facilitate the discussion, I would like to move that we accept those recommendations as board approved and intended. So
Second.
Thank you for the motion and second. Is there further discussion? All right, seeing none, we'll ask for public comment, please.
Okay, if anyone would like to make a public comment now on agenda item number 25, please go ahead and indicate so. Okay, first up we have Katrina Reyes. Katrina, are you there?
Yes, I am. Thank you. Good afternoon, Katrina Reyes with the California Academy of Family Physicians. Thank you to Ms. Melby and Mr. Bone for presenting on the implementation of AB 890. Thank you to the board for including involvement of the board in the implementation of AB 890 as part of the board's actions. CAFP supports the board monitoring and being an active participant in the promulgation of regulations and guidance by the BRN throughout the implementation of this new law. We further support the recommendation that the board and board staff evaluate whether board regulation or policy changes are necessary. While the statute explicitly requires regulatory action by the BRN, it will require involvement, including possible regulatory action by the medical board, whose licensees and policy jurisdiction will be impacted by AB 890's implementation. For instance, it is expected that AB 890 regulations would need to address the conditions and standards in which the new categories of NPs consult with and or refer patients to physicians. In addition to this, physicians' legal responsibilities and duty of care when working with the new categories of NPs will also need to be a subject of evaluation. Patient safety and consumer protection must be a paramount priority in the implementation of AB 890. Guidance from the board and how the board views the roles and responsibilities of physicians under this new law is necessary. We look forward to working with the board and board staff as we explore these important considerations. Thank you.
Thank you for your public comment. Next up, we have Yvonne Chung. Yvonne, are you there?
I am. Good morning, Yvonne Chung with the California Medical Association. We support the proposed plan for engagement on AB 890 implementation and appreciate the board's commitment to continuing to monitor and participate in this process. As we have previously communicated, patient safety and consumer protection must be a priority in the implementation of AB 890. Elaborating on item 4 in Mr. Bone's report, we continue to urge that the board develop guidance informed by a thorough policy and legal analysis of AB 890 on how the board views the role and responsibility of physicians under this framework. We believe this is necessary to better understand the physician's duty of care and potential liability risks that may be created. Moreover, in light of the expanded functions that NPs can perform, we encourage an assessment by the board on how the regulations can impact the practice of medicine and provide information to its licensees regarding appropriate supervision where required. We believe this process can be informed by an interested parties meeting with board licensees across specialties and practice settings, and CMA looks forward to working with you throughout this process. Thank you.
Thank you for your public comment. Next up, we have Eric Andrus. Eric, are you there?
I'm here.
Please go ahead.
Just my regular disclaimer that 1/3 of California's doctors do not belong to the California Medical Association, and of that third, most of them have to join due to mandates from their local medical societies. So they don't represent all the doctors in the state. Thank you.
Thank you for your public comment. At this point, Ms. Lawson, there are no other requests in queue.
All right, we'll bring it back to the board. We did have a motion and a second on the table. Is there any further discussion? All right, seeing none. Ms. Caldwell, would you call the roll, please?
Ms. Campoverde?
Aye.
Dr. Gonadev? Dr. Hawkins?
Yes.
Dr. Kraus?
Yes.
Ms. Lawson?
Yes.
Ms. Lubiano?
Yes.
Dr. Lewis?
Aye.
Dr. Mahmood?
Yes.
Dr. Thorpe?
Aye.
Dr. Tirado?
Yes.
Mr. Watkins?
Aye.
Dr. Yip?
Yes.
Thank you.
Thank you. The motion carries and the implementation plan for AB 890 is approved. Excuse me. Moving on to the next item, 26, future agenda items. Do any members have future agenda items they would like to?
Ms. Lawson, this is Howard Kraus. It's not an urgent matter, but I would like us to have some expert presentation on CME. And that is to say that we acknowledge that CME is appropriate for a physician to maintain good practice, and it's required for renewal of licensure. But I don't know that we ever look at the product to do any kind of outcomes analysis or verify the value of the CME credits that our physicians are taking. So if we could have some expert from UC Davis or another appropriate California academic institution give us a presentation on CME, and we can begin to think about, number one, quality assurance of the CME our physicians are taking, and number two, since it's a constant source of legislative action, to also have an expert opinion on the role of government in legislating CME. So I think that's an appropriate future agenda item, but again, it's not an urgent matter.
Thank you. Are there additional?
Dr. Mahmood?
Dr. Yip.
Please.
Yeah, I want to focus on in near future about focused role of board to reach out the public, not just through our website, not just through the physicians or other allied organizations, but direct public reach out, because it is very important that public and consumers trust us and they have no barrier to reach us out. So I think there has not been any real effort as far as I am aware after my research. So we should have either a task force, or we should have some committee or some people from the board who reach out directly public and come up with some ideas how we can create confidence, and public have this confidence they can reach us anytime they want to, whatever way they want to. So that will, I think, restore or elevate the impression of board that we are there for the public safety and consumers protection than anything else.
Dr. Yip? Dr. Yip can come in. Yeah, we actually have a committee task for that. Actually, Dr. Lewis, Dr. Hawkins were involved like 5 years ago, but certainly a good time to revisit and make another outreach effort again. That actually explains why there was an increase in the number of complaints. We actually thought about having notice in employee paycheck stuff and how to reach the board. One of the things I suggest to in the future, if possible, have a presentation on alcohol abuse or substance abuse. We have cases that how we define alcohol abuse and whether they are chronic abuser. It would be nice to have presentations from psychiatrists, psychotherapy, even a DAG office. It would help us to look at the guidelines, how to look at refine the guidelines in the future. Thank you.
Thank you. Additional
This is Lori.
agenda item?
I have an agenda item.
Please.
Thank you. Building on Dr. Krause's request, I wanted to raise an agenda item on cultural competency. I know we've talked a little bit about that yesterday and in previous meetings, and I think in this climate where there's an increased demand for diversity and inclusion, in addition to the fact that we know that there is a shortage of doctors and a projected shortage of doctors in the future, I think it's important that we further equip our frontliners with this kind of training. And I'm aware of Business and Professions Code 2198 that addresses cultural competency, but it describes it as voluntary. So I'd like to see, what we can do, whether it's at the school, working with the schools or with CMEs, but specifically, I'd like to see what we can do to make that a requirement. Thank you.
I'd like to add that that's very good and appropriate to add into the CME discussion. And I'd like to note that actually every time I declare a CME credit, I am asked as to whether or not the CME program included issues of cultural diversity. So I know that it's tracked, but again, we have to look at the outcome. Very often we legislate and we require programs and we don't necessarily review the outcome. So reviewing the outcome of cultural diversity within CME as it has existed to this date is very appropriate. Thank you for that.
I have a future agenda item request as well. This is TJ Watkins, and it is a follow-up on something that took place in this meeting. I want to just make sure that we, the board, has followed up on those Bakersfield calls, and just to have someone report back to us that it was looked into, that whatever the findings are. I'm really interested in that. Thank you.
Thank you. Additional agenda items? Ms. Tirado? Excuse me, Dr. Tirado.
It's okay. Hi. So I was wondering if we could also talk about telehealth and like regulations, changes in expectations.
Thank you. All right, any additional future agenda items before I open it up to the public? All right, Sean, let's open it up for public comment, please.
Okay, the Q&A window is open for anyone wishing to make a public comment on agenda item number 26. First up here, we have Christina Hildebrand. Christina, are you there?
I am.
Please go ahead.
Hildebrand from A Voice for Choice Advocacy. There are two items, or actually just one item. Looking at the standard of care and whether that is what doctors should be held to versus newer research and newer treatments. and how, when they are brought before the medical board, whether those newer treatments should be allowed as their way of treating. There's the, there are various legislations that show that if you're giving a treatment that is not FDA approved, that's off-label, there are certain stipulations that you have to show that there is reason for you to give this, and there's a huge long list that you can go to, and I would like to see the medical board look into that and adopt that rather than just going with what standard of care is, because standard of care takes 17 years to get from a book from a research paper into a doctor's office. And I don't think that's where California wants to be, even though we lag behind in so many other things. The other thing I just wanted to point out is I've now learned my lesson that do we just need to get people on the phone giving their sub stories for you to listen to them, given the whole Bakersfield issue. It's good to know that you're so caring about the people, and not that I want to diminish them at all, but it's wonderful to know that if we get enough people on the phone that you'll actually do something, which hasn't been my experience in the past. Thank you.
Dr. Hawkins, can I ask a question? I'm not sure I understand what Ms. Hillebrand is asking us to do, but maybe everyone else does understand.
Ms. Hildebrand, your line is still open.
Sure. For the first agenda item, I'm asking you, so currently there are many doctors that have been brought before the medical board, especially on the medical exemption issue with vaccinations, that are being held to the standard of care. The standard of care is defined as what is currently done as the norm to treat a diagnosis or symptoms. So for MS, or cancer, let's take cancer. Cancer, the standard of care is chemotherapy, radiation, or cut it out. If you go to the Mayo Clinic, they are using genetic treatments. They're using all cutting edge stuff. That is not considered standard of care. So there are doctors that are being told that and being put on probation because they are using standard of care because they are not using standard of care. They are using new research. They're using, basically treatments that are, or research that has been put out in the last 5-10 years maybe, which is not considered standard of care because it hasn't made it to the mainstream doctor's office. There's research that shows it takes 17 years to get from the research, from a research article into a doctor's office. I am asking you to put together and I'm happy to please conclude people to speak on this, but to basically put together a presentation on why standard of care should, when standard of care should be used and when new treatments are allowed to be used and not be seen as diminutive or seen as bad when brought before the medical board.
I understand now. Thank you very much.
Thank you.
Thank you for your public comment. Next up, we have Eric Andrews. Eric, are you there?
I'm here.
Please go ahead.
First, Dr. Mahmood, according to the Sunset Report, there already is a public outreach committee. It's one of the 6 standing committees. Does no one serve on it, or is that committee failing? I would like an agenda item to talk about controlling Carrie's unfounded and overreaching supervision of calls and teach her what she can and cannot do when overseeing a meeting, because she was clearly out of line today in breaking the First Amendment, my First Amendment right. Here is some information to ponder in the meantime on that. Nearly 30 years ago, the Supreme Court ruled that profanity cannot be banned under the First Amendment. In Cohen versus California, 1971, Justice John Marshall Harlan II reasoned that, quote, while the particular words being litigated is perhaps more distasteful than others of its genre, it is nevertheless often true that one man's vulgarity is another's lyric, close quote. In U.S. District Judge Dean Ferguson in 2013 ruling in Los Angeles, on behalf of residents who have sued City Hall over attempts to control their rants, he said, it is asking much of city council members to tolerate profanities and personal attacks, but that is what is required by the First Amendment, Carrie. I suggest Carrie read that document and familiarize herself with it, as well as the intricacies of the Open Meeting Act. I'd like an agenda item to show the public how they're supposed to know which cases they're not allowed to talk about when the board refuses to make complaint information public. A quick suggestion for ease of agenda use online. Lots of online meeting apps, especially ones the legislature uses, have a function that allows viewers to see what agenda item you're currently on. I'll admit that sometimes I tune out on the boring agenda items, but I have no way of tracking where you are in the meeting because there's no indication of it on the screen. This WebEx software is the worst of all the ones I use, but it must have a function for agenda titles. I would like to see an agenda item on how COVID has affected doctor discipline. If you all didn't see it, in September, USA Today published an article titled "Discipline Against Bad Doctors Plummets Amid COVID-19, and More Medical Errors May Slip Through the Cracks," where it says that emergency actions against doctors' licenses dropped 59% from April through June of 2020 compared to the same period the previous year. Thank you.
Thank you for your public comment. Up next, we have Marion Hollingsworth. Marion, are you there?
Yes, I am. Can you hear me?
Yes, please go ahead.
Thank you. I have two suggestions for future agenda items. One is to report back on and review the disciplinary guidelines and how the board is or is not following them. We've had quite a bit of discussion about that, Mr. Watkins brought up, and from what we've seen from cases coming out, like the doctor in Lakeport who had 4 deaths and only got 3 years probation. Things like this need to be identified to say, actually to see how the disciplinary guidelines are or are not being followed. Number 2, agenda item suggestion, to have doctors identify themselves for telehealth appointments. You need to review how telehealth is used. I mentioned yesterday, there needs to be some protocol or informed consent for the process so patients know the true identity of the alleged medical professional who is talking to them. And this is especially an issue since the patient ban in the hospitals, the patient ban in nursing homes. We cannot see the person we're talking to all the time, especially if it's a phone call. So if you could review that, have a report back on that for the next quarterly meeting, that would be greatly appreciated. Thank you.
Thank you for your public comment. Up next, we have Yvonne Chung. Yvonne, are you there?
Yes, thank you. Yvonne Chung, California Medical Association. One suggestion that we have for a future agenda item would be a presentation to the board on the bar on the corporate practice of medicine. This is becoming increasingly relevant as practices are being purchased and new corporate structures are being formed, and the impact that that makes on how physicians practice and the board's role in enforcing the corporate bar. Thank you.
Thank you for your public comment. At this time, I do not see any additional requests. Ms. Wilson.
Thank you very much, Sean. Thank you to the public for those suggestions and recommendations. We'll bring it back to the board. Are there any other future agenda items you'd like to bring to staff's attention at this time? All right, seeing none, the final.
I have one.
Sorry, Madam President. Okay, please go ahead. Go ahead, Ms. Campaverde.
It's Alejandra. I'd love to see a presentation in the future of how our medical experts are identified, recruited, trained.
Thank you. Add that to our list. All right, if there are no further comments, our next item is adjournment. So there being no further business, the meeting is adjourned. Thank you to the members. It was good to see you. Thank you to all the members of the public for participating. And I believe the next meeting of the board is scheduled for May 13th and 14th. And my understanding is we'll continue to hold these virtually for the foreseeable future.
Thank you.
Thank you. The meeting's adjourned.
Thank you.
Good day. Thanks.
Thank you.